Good evening, everyone, and welcome to the Lancaster Community Library. I'm Alice Cooper, the director here, and we are really excited about having Alfie here to speak on estate planning. Before he steps up, I would like to mention a couple of activities upcoming at the library. This is our second summer of a special evening with series, and Alfie is in that series. Our next big event for actually all ages, including grown-ups, is our Author Expo. The flyer's on the table here. I hope you'll be able to come. We're going to have about 40 authors here from the region who write about all different topics, all published authors. And July 8th from 1 to 4 p.m. We're really excited that best-selling author Christina Dalcher will be here as our keynote speaker. So hope to see you there. And without further ado, I would like to welcome Alfie Butts here with Tidewater Trusts and Estates. He very kindly has agreed to enlighten us all about estate planning. So thank you, Alfie.
That's right. Is that working? Did you say 40? 40 authors?
Yes.
Wow.
Yes.
That's a big group. Anybody heard me talk before? It's going to sound familiar then. So when clients come to see me to talk about their estate plan, we've got to talk about the basic documents and what actually estate planning is. I do want you to interrupt and ask questions. I think if you can ask questions while we're on the topic, it flows better and it's better for everybody. So just jump up and down and do something, and a microphone will show up right beside you, I think, is the plan. Is that the plan?
Yes.
Okay.
That's the plan.
So estate planning is the process of arranging for the management of your assets and your well-being during your incapacity, and to transfer those assets to your chosen beneficiaries after your death in the manner that you choose. So your stuff is going to go or be held for your benefit. You're going to pick who manages it for you. At your death, you're going to pick who gets it to your beneficiaries and under what conditions. So that would include documents. That's it. That would include documents such as wills and trusts, medical directives for who's going to make your medical decisions if you can, and powers of attorney. The other things that are mixed into that are designating distributions of assets upon death using beneficiary designations like life insurance, payable on death designations, and transfer on death designations that sometimes we use on cash accounts and securities accounts. So when you do a beneficiary designation or a POD or a TOD, you are directing those assets directly from the account holder. They won't run through your will, they won't run through your trust unless you direct them to that. So you can, in a very simple manner, do your own planning in POD accounts. I will give you a little bit of caution, or a word of caution about that in a few minutes, because sometimes you cannot take care of the contingencies for PODs and TODs and beneficiary designations. We also change title to real estate quite often. Sometimes we'll do a transfer on death deed. We did a couple this week. Simpler plans with limited beneficiaries and limited assets. It's very easy to put a TOD on a piece of real estate so that if that child, if those children survive you, they end up with it. And there's no probate or anything because it's right there on the deed. When I die, my child gets it. We'll shift, when we have a trust plan, we'll shift the actual ownership of the asset to the trust. Now the reasons for estate planning, and I probably could have written 100 of these. The main ones I just mentioned is choosing your beneficiaries so that you're determining who's going to get your assets, and the law doesn't determine that. Because there is a set distribution scheme for intestate folks, people without wills, and it may not be what you want. Creditor protection, sometimes if you leave money to a child, they've already got judgments, the judgments come in, swoop it up, and that's the end of it. You want to leave it in a trust or some other vehicle that's protected for them. You deal with uncertainty. You plan for now. I got to remind clients, they say, well, I'm not going to die for 10 or 15 years, and I just kind of work out. So plan for now, adjust later. You don't know what's going to be down the road. If you've got a plan in place, making those small adjustments to the changes in circumstances is pretty easy stuff. Special needs, we do an awful lot of special needs trusts. So special needs are mentally, physically handicapped kids, relatives, parents sometimes. A child will leave a trust for a parent if they're not able to care for them because they're deceased at that point, and then it was for the parent and goes to their kids. A lot of alcohol problems and drug problems, especially recently. So we have special needs trusts that will hold that under certain rules for distribution for the benefit of the trustee, mostly for the benefit, with the trustee handling it, and it doesn't count as a resource for qualification for certain benefit programs, state and federal benefit programs. So you're not disqualifying them from other things that they would be able to take advantage of. Medical concerns, divorce, so that's not your divorce, but it could be. You could plan around that, but that's going to be a tough conversation at the table with your spouse. But really talking about your children's marriages and planning to set things up for them so that they don't become, the assets you leave them don't become part of the marital claim if it hits the fan. Be careful when I say that. Income tax liens, if you leave it to the children in trust or some other vehicle, maybe it's not subject to the income tax man coming to collect. And guardianship, business succession. We get to do some of that here, but not a lot, because most of the folks that are here have taken care of that, cashed out, come out to enjoy the river. But there are some local businesses that we do some succession planning, which is a lot of fun, actually. Avoiding probate is one of the primary reasons for doing your planning. Virginia has, I would say the process in Virginia is somewhere in the middle between easy and ridiculously difficult, like California and New York are on the ridiculously difficult end. But Virginia's in the middle, but it's a process that you don't necessarily have to go through. Probate tax is not horrible, but you could spend, if you $1 million or $2 million state, you can spend $3,000, $4,000, $6,000 in probate tax, and you're going to pay a lawyer to help. Somebody's going to pay a lawyer to help with the accounting and the inventory because they are not intuitive things. So if you plan well, you can avoid at least most of that probate with the big assets. Blended families. This is almost 50% of what walks in the door. His and hers and ours, his children, her children, we don't have any children together, or maybe they do have one. So we end up looking at what the priorities are, what are you going to keep in place for each other, for the survivor, and then where do the assets go and how do they maintain separation, if that's the idea, or do you throw them into one pot? And whoever is out on last can make the decision to change it. A lot of things to consider with blended families. Family harmony. So I recently had to do the fiduciary work, be the executor trustee on an estate where there were multiple children, and the parents didn't feel that appointing any one of them would be beneficial to getting the work done. So instead, they told them that somebody else was going to do it, and all they have to sit back, all they have to do is sit back and wait. I don't necessarily encourage that. I think if you've got competent kids, they're the right ones to do the fiduciary work. They can always go get help, and they can negotiate with whoever they're going to or find somebody they're comfortable with to give them the advice. You don't want to lock them in, but in this situation, I think maybe it's a really good idea to have an objective third-party person do it. Trust. I mentioned that a second ago. Incentive trust, please behave or you're not going to get your money. Sprinkling trust, I'm going to give you a little at a time so you don't spend it all at once. Education is usually a priority for folks with their grandkids who put it in there until they turn 25. Usually they're through school by then. The trustee can pay for school and then give them the rest when they hit that age. Retirement accounts are important to consider. They have beneficiary designations, and the rules and the income tax deferral makes a big difference in how you plan for them. Privacy. Trusts are private, wills are not. So I'll talk about the probate process a little bit and explain that. When you go probate a will, Uncle Jack dies, he's got a house, a bank account, a securities account, some tangibles. I'll go put his will on record and he leaves it to all of his nephews. I've got to go qualify and I've got to file a list, an inventory of all those assets with the approximate value of those assets. It's right up there, you can go look at it. Then I've got to file an accounting and show the bills I paid and the distributions I made to where I got it to zero and everybody got their equal share out of that. You can go look at that too. With a trust, none of that is on record. It is available to the beneficiaries. The trustee certainly needs to be transparent, but it's not on record, so everybody and their neighbor can go look at it. Some other reasons to plan. If you have a non-citizen spouse, did I go the wrong way?
You just skipped one. You skipped the management of assets, loss of capacity.
That's right.
Okay, time accounts privacy. All right, non-citizen spouse, if you have a non-citizen spouse, there are some different rules. Once you get to taxable estates, you've got a different ballgame. So I would encourage, without getting too deep into that, encourage anybody that has a non-citizen spouse to go talk to an estate planning attorney. Unmarried partners, folks come in, they've committed but not married because they're either late in life or they're early in life and they're not sure they want to do that, and it's unusual planning. You don't have the same benefits with a marital deduction and the rights of spouses and so forth, but you can plan together even if you're not married. Remarriage of current spouse after your death. So this is what we talk about when we're at the table. We talk about Trixie and the pool boy. So you need to think about the assets and what's going to happen if something happens to you sooner rather than later and your spouse remarries or doesn't and possibly comes under the influence of somebody else. Do you lock it down and just live with it? Do you lock it down and make sure it's going to happen, or do you hand it to he or she and hope that that moral obligation keeps things right on track? Charitable gifts often come up when you're doing planning. Current gifting, giving the kids some money to decrease your tax consequences and help them out a little bit each year. I've never had to deal with it, but assisted reproduction. If you've got some frozen things somewhere, and that my clientele is a little older than that, then you really ought to have that in writing what's going to happen to them, because that can cause a whale of a lawsuit one day. And actually potentially child support payments that you weren't counting on. If you want to disinherit your spouse, if it's a second marriage and you want to give everything to your children, there's some consequence to that, because Virginia's got a spousal elective share rule, which means the longer you're married, the more you're entitled to by election. We used to have a very sharp rule that if you were married, you got a third. I didn't say how long, right? So now we have a rule that vests over a 15-year period. You start at this is awkward, but start at 3% of 50%. And each year you vest a little bit more. At 15, you're entitled to half. So if you think you're going to do your own thing with your assets and that was your agreement, you really need to talk to somebody, maybe even put a post-nup in place so that you waive those rights at death, because they can throw a wrench in what you're planning if your spouse has different ideas after you're gone. And when I say gone, I mean dead. Sometimes I just don't want to say dead. The state taxes used to be a much larger deal. Almost everybody that came in was subject to it because we were down at 600,000, $1 million, and $1.5 million, and that's about the average price of a waterfront house around here. Now we're at 12.9 million each, and we have portability, which means you can give your credit to your spouse and add it to theirs. Taxes aren't as big a deal around here. I do have a few taxable clients. We have some gifting plans out there and some hedges, but most folks that come in aren't worried about assets over 12.9 and having to pay off the same. And I can go on, but this is just the reasons for planning and the things you need to think about that you just can't handle with a payable on debt designation or really simple will. So we'll dive into the documents a little bit. The big three are the power of attorney, the advance directive, and the will. A power of attorney is a document where you are appointing another person to act on your behalf. Almost anything you can put in there, you can allow them to do. Almost. You can't allow them to get married for you. You can't allow them to adopt a child for you, and a couple other ones. But a power of attorney can be very narrow. You can help sell my house. I'm going to Argentina for a month, and the house is under contract. I'm giving you a power of attorney to sign all my closing documents. It can be very narrow, or it can be very broad. It's what we call a general power of attorney. A general power of attorney generally has a list of paragraphs with very express authority in it. Read them if you're going to sign them. Don't be surprised about what's in it. Durable is what you want. Durable power of attorney survives your incapacity. So if you sign it now and you lose your wits, it's still gonna work after that. I don't really understand the advantage of one that goes away when you lose your wits. I've never drafted one like that wasn't durable. Almost everything I've drafted has been durable. Springing is what a lot of people think of a power of attorney. It comes to an existence and works if I'm incapacitated. That is not generally what you see. What you generally see is a power of attorney that works when you sign it. So if you've signed it, you've authorized that agent to do the actions in it. A springing power of attorney says, upon my incapacity. That's not the case with most of them. So if you're printing one somewhere, somebody gives you something that's just kind of a standard one, it's not going to be a springing power of attorney. It is very rare that I do a springing power of attorney. The springing power of attorney is logistically a nightmare because the banks want proof every time somebody uses it that the person is still incapacitated. So it's a good thing to avoid. There are some situations where they're important, but generally what you're going to see is a general durable power of attorney. Yes, ma'am?
Does a durable power of attorney have an expiration date? I mean,
It only has an expiration date if you put one on it.
oh, okay.
So I've done them before they expired because people were going on a trip and they wanted to be non-functioning when they got back or when they were scheduled to get back. But no, they don't go stale.
Okay.
It's a good question. Thank you. Let's see. They're very critical if you're temporarily or permanently incapacitated. Somebody's got to pay your bills, get your mail, file your tax returns, deal with contracts, the financial end of your care. It is really important to have that document. And what can you do with a power of attorney? Like I said a minute ago, almost anything you put in there you can do. Here are the things you need to be really careful about. And this comes when you're getting one off of that website that I'm not going to mention the name of, or borrowing one or copying one from somebody. If it gives you the ability to create, amend, or revoke a trust, you got a problem. Because if you created a trust and you give somebody else the ability to change it, that doesn't make a lot of sense to me. It's your trust, you want the ability to change it. There's a reason you put it in place. To make a gift without limitations would be a real problem because somebody could bankrupt you real quick. To create or change rights of survivorship, to change beneficiary designations on your life insurance, your IRAs, to change PODs to TODs, is an issue because if I've got those superpowers, is how we talk about them in my office. If I've got those superpowers, I can go change your entire plan. A lot of times the spouses will give those authorities to each other to make the plan very flexible, and it makes sense. But we don't necessarily give them to the kids, and we certainly don't give them to the cousins and whoever else that we don't want really in there being able to change anything. So you got to read these documents. They're not just boilerplate. You got to understand every paragraph when you sign them. And if there's something in there that makes you uncomfortable, pull it out. What I don't like are the ones where you have to initial by each paragraph because you can't tell who initialed that and when. So if you're going to do one, get a fully done printed document that doesn't have anything that you've got to make an adjustment in the middle. Just sign it like it is. So it's very obvious what happened. So the other question I get a lot about powers of attorney is, am I giving up my right to manage things? No, you're not. It is a co-right that you're authorizing somebody else to do the same thing. So you haven't lost any authority. You still have all your authority. And the person who's your agent has the same authority, or the authority that's outlined in the POA. And you can revoke it like that. You can actually revoke it verbally. You can tell them not to use it again. You should actually revoke it in writing and deliver the notice to them, but you can revoke it verbally and it'd be effective. What are my agent's obligations to me? Their obligations are fiduciary obligations to you to take care of you and manage things as you would have, or as close as they can get to it. So you give it to somebody you trust, they're legally and civilly obligated to do the right thing for you. I'm going to tell you it doesn't always happen, but that's why you're careful about who you put on, and please have some alternates if you've got good people you can trust. I'm going to name my wife, and if not, then my brother. If not, then maybe my dad is the ultimate backup. And like I said, Dad's older than I am, so he might not be around to do that, but I'm planning for right now. I'm not planning for 10 years down the road. Some other documents you are going to run into, so the DNR, DNAR, and AND. DNR, DNA are the same thing, more or less, it just depends. Oh, I'm sorry.
Another question.
Okay,
What
sure.
if you don't have anyone that you can trust to designate? Can you designate a law firm or?
You actually can designate a professional or trust company. So it's people you trust, professionals you trust companies you trust. I would, if I was considering a trust company, make sure I had a relationship with them, because it's all about the people. It's not necessarily about the size of the company. In fact, the bigger ones are probably not suited to do those kind of things. And especially a professional, CPA or lawyer, somebody that's understands the fiduciary requirements and obligations. There are some duties if you're acting under power of attorney. You need to keep really good notes about everything you do, because it could be requested by a person of interest that you have to prove what you did. So when people say I'm gonna start acting as my parent's agent or my cousin's agent, I say get a notebook, write down what you do every time you do it. If anybody ever asks, you copy the notebook and the account statements and hand them. And then you've been very transparent, which is the idea. So the DNR, do not resuscitate. This is not a document you need to be signing in a lawyer's office. You do this with your doctor. There are 2 signature lines on the DNR. And I used to say it was a yellow piece of paper with a red stop sign, which some of you may find familiar, but I was corrected that it's no longer yellow or in red, and it can be black and white, and copies work. So that is a document that says, if my heart stops, don't start a document. Do not attempt resuscitation. That's what that is. The allow natural death document is not something I see too much, but it depends on where you're getting your health care. It is a list of what you want as far as comfort and pain management. Like, don't give me the opioids, give me all the Advil you can give me, or a good bottle of bourbon will do it, or however you want to handle that. You leave those instructions, and you come up with that with your healthcare provider. Live and will. So live and will is about this long. In my documents, it's 1 paragraph of a different document. I'll get into that. But a live and will is your desire, your statement of desire, that if you are in a terminal situation and you're on life-sustaining treatment, you want it removed. So if there's no hope, unplug me, unhook me, whatever it is that's keeping you alive. Could be nutrition and hydration. It doesn't necessarily have to be a machine. Medical power of attorney is the designation of an agent. So sometimes when you used to go to the hospital, they say, do you have a living will? It's a little 1-pager, you sign, you pull it off the gum pad, you sign it, you got a living will. Identifying or appointing somebody as your agent to make your decision, if you can't, it's a different document. So you're saying that the person who you put in this position is going to be able to make any kind of medical decision about giving you care, withholding your care, any type of care, or how you're going to be treated, if you can't communicate with your healthcare provider. So that's what a medical power of attorney is. What we do most of the time is called an advance directive. So an advance directive has the live and will as the first main paragraph. So you're educating your agent as to what you want in a terminal situation. It then appoints your agent and the alternates, excuse me. And then it goes on to do a few other things. Mine talks about organ donation. I'll come back to that in a second. And then we have a section called protest or psychiatric directive. So the organ donation, it says generally it's okay to donate more organs. Some clients are aged out of that, so it's really a moot point. But it's okay to donate, but I'm leaving the decision to the agent that I've appointed. Now this is living donation. This is beating heart, helicopters, and coolers donation. So you're giving them the ability to do it. Some clients say, I don't want any of that, and we'll change that part of that document to say there will be no donation of any part of my life. And that's it, it's the end of it. What you need to understand is Virginia has a 2-pronged test. If I've declared I'm an organ donor and I meet the condition of an organ donor, brain death or cardiac death, then the organ procurement group comes in and can evaluate me and take the organs that they need. 2-pronged test. So how many folks have a part on their driver's license? You have a declaration to be an organ donor. So if you roll down the steps here and have a bleed and they keep you alive and you're brain dead, you have declared and met the condition, and they're going to come in and get what they want your family's not gonna be able to do anything. They're not gonna be able to participate. I'm not saying it's a bad thing, but I want you to understand it, and nobody understands that. You check the box at DMV and you feel good about it, which is great. And just because you take yourself out of, I gotta be careful which finger, take yourself out of the two-prong test does not mean you're not gonna donate. What it means is your agent makes the decision at the time under the circumstances. So your agent, if they have the authority and you're one and not two, then they can say, okay, you take what you want, but let's get everything done by Thursday because we're gonna have a funeral and we really like her and to be there. So you kind of got to think through that. That hard on the driver's license puts you in a completely different category. The way to undo that is to go get your license reissued, and then there's a link on Life of Virginia website where you can take yourself off the list. So you've undone the declaration, and if you meet the condition, then your agent can control it. I'm not telling you which decision is right. It's completely up to you, and everybody's different. I'm okay with it happening so that the burden of that decision is not on my family, and they all understand that. But a lot of folks don't understand how that works. So that's something you gotta look into and make sure that how you have things is how you want them, and that your family understands that. The donations can take weeks, so they're keeping you alive for weeks until they get everything lined up logistically and get it done. So you just wanna make sure they're prepared. Easy place to get a directive is that website right there. So that's gonna have all the bells and whistles in it. It may not have the psychiatric directive in it because that requires a doctor to sign it when you prepare it. I haven't looked at the website in a while, but they're free, print them out. Again, I don't like the ones with the check the boxes. I don't think those have them. I think that's a solid form with no initials required. Let's see. If you don't have a directive, this is who's making your decision. If you're under a guardianship, your guardian. If you have a spouse, your spouse. If you don't, then it's going to be your adult children, and then your parents, and then your siblings. So at some point, there may be somebody you don't want making a medical decision for you, or you may not have access to any of them. So it's really good to have the document to appoint who you want. I actually had a client who appointed a friend, and I had to walk by her children in intensive care to give the friend the directive, because she did not want her children to have to make that decision. I think it was because they might not have had the wherewithal to pull mom's plug, but that was an unusual situation. That was difficult for everybody. Let's see, okay, so here's the psychiatric provision. So in 2012, they changed the rules, the law, and they said, we're gonna try to clear the capacity hearings and the guardianship as much as we can from the court. And we're gonna allow an individual to give their agent the ability to make a decision over their objection requiring their physical or mental health treatment if a doctor documents that they're suffering from a mental illness or defect that needs to be treated, evaluated and or treated, whether it be temporary or permanent. So what that says is, if I have this provision in my advance directive that says, if the doctor documents that I'm suffering from those issues, then I no longer have the ability to make my decision, and my agent can make my decision, which includes involuntarily admitting me to a place like Bridges for evaluation and treatment. Then I have stayed out of the court for a capacity hearing. I've stayed out of the court for guardianship. I've taken the burden off the court. I've given the power to somebody that I trust, that I pick, and then they can make the decisions about my treatment until the doctor says I'm okay. There's still a safeguard there. If you go streaking through Walmart and they get you in a straitjacket and they haul you over to Bridges, the doctor can keep you for 72 hours. If you're there for 72 hours, the judge shows up, they have a little hearing, they talk about whether you should still be there or not. In the case where you're appointing an agent under this provision, it's a 10-day window. So there's still a judicial review at 10 days if you're still over there. They've got to provide evidence that you're not well and you need to be there for treatment. But this provision is really important. It gets you help quicker. I've had situations where we needed it and didn't have it. And we had to rely on Adult Protective Services or the Sheriff's Department to get involved and kind of get these people away from where they were and get them over to some treatment. And I've had situations where we've had this and it's just worked beautifully. And I'll give you a little insight. the older you are, the harder a UTI hits you. And folks will lose their mind for a week. And if you see that happen to somebody, and then you learn what caused it, you will recognize it the next time it happens. This provision, if they're off the rail a little bit because of that, will allow you to kind of round them up and give them some treatment, and as soon as they're feeling more like themselves, then they can come on back and move on. Designation for persons to make, yes ma'am.
Well, while we're on the subject of medical types of this, and this might be maybe too medical, but I bet you know the answer, and that is, for a DNR, I recently was in a small group and there was a lot of disagreement about what that really entails, because if you suddenly stop breathing or your heart stops, who's to say you might start breathing again? So the point is there a time frame? The conundrum with everybody talking about it was like, I don't want to have a DNR because I could get resuscitated without it being a terminal death.
Did not sign it.
Right.
So
That was sort of a scary talk.
I had a client who's about 50 sit down across from me and dumped all his paperwork that he'd done somewhere else on the table. And I could see that DNR. And I reached right over and I pulled it out and said, why do you have this? And I expected a conversation about his, I don't know, some kind of cardiac issue where if he had a heart attack, he didn't really want to be around. The doctor just signed it for me, said I needed it. I said, you need to tear this up, because if you go out and lean on the phone pole and get a little electric shock and your heart stops, and this happens to fall out of your pocket, when the emergency guys get there, they're not touching you. So that's what it does. So you need to understand when you sign that, this is the conversation you have with your doctor, that there will be no treatment if your heart stops. And you need to be okay with that. And I'll give you the flip side of that coin. I had a lady come in, she was 92, and in fact came to my office driving. Fantastic shape, and she had a DNR. I said, why have you got the DNR? And she looked at me, she said, because I'm 92. I said, yes ma'am, I understand.
I get the picture,
Okay.
thank you. Perfect.
So, designation to make funeral arrangements. So your remains do not flow through the orders of your will or your trust. Your remains belong to your heirs at law under Virginia law. So if I've got two estranged children and my wife has predeceased me, when I die, they get to say what happens to me, not me, even if I've made a pre-need plan. So if you got a situation where you need somebody other than your heirs at law, or you have no heirs at law to depend on, you need a burial directive that appoints somebody to sign off on whatever's going to happen to what's left of you when the time comes. And I'll tell you when this goes bad. Had a client who was estranged from his family, died, did not have one of these, and we could not find his relatives. And it took a month. And we finally found overseas two cousins. And he was, like I said, he was estranged from his family. And his friends had gotten together and kind of made a plan. And we asked them to approve that. And they said, no, he's going in the family plot. So off he goes to the family plot, where I know he didn't want to be. But this is the kind of thing you got to think about. And maybe you don't care. Maybe you think they're just going to burn you up and throw you in the river, which is fine too. But just don't sound fun. But you got to kind of think through, and then who are you going to put the burden on? So if you don't have anybody to lean on, maybe your friend will do it. The easiest way to get somebody to help you with this is to go to the funeral home and do your pre-need plan and lay it all out for the funeral director. They'll have a file and they'll keep it and put the contact information in there for the person you appoint. And then when you're dead, all that person's got to do is sign the form at the funeral home so that they can take action, because they're not going to do anything until they get a signature. But if you got lots of kids, spouse, cousins, parents, sisters, brothers, you're fine. Somebody will tend to it. Doesn't mean they have to pay for it. It just means that they've got to sign off on it. But if you're limited in your relatives, you need to find somebody you trust that will take care of that for you. Just to be thorough. So, a will, everybody pretty much knows what a will is. So that's last will and testament. Here are my desires, sound mind and body. I want my house to go to my son and my Rolls Royce to go to Trixie, and that's it, and pay my bills and so forth. And here's the person that's gonna do it, name the executor. So the requirements for an effective will in Virginia are a signature and 2 witnesses. We have a holographic will statute that says you can write it all in your own handwriting and sign it. Please don't do that. There's books written about that, there's movies from that, and it almost never works right. But we do have a holographic will statute, this Commonwealth and 2 other Commonwealths actually. We also have a substantial compliance statute. And the substantial compliance statute says if you can prove clear and convincing evidence that this was supposed to be done a different way, then we'll let it happen. Really, the only way that works is if the lawyer gave you her will and him her will and her his will, and you signed each other's wills. It's the only time I've seen the substantial compliance section work. Because you definitely intended to sign it, there's evidence because you signed something at the same time. But that's an interesting thing, and it presents an opportunity to get a slightly defective will into probate. Often you'll see a notary, so you've got a signature line for the testator, you've got the 2 witnesses, and you've got a notary. Well, the notary is a self-proven affidavit. It's not necessarily part of the will, but it's the notary's certification that everybody was in the room, everybody's looking at each other, and everybody's signed in front of each other, which is the requirement of the will. If you have a will that does not have a self-proven affidavit on it, it does not make it deficient. It works, but when you die, they've got to track these witnesses down and get depositions from the witnesses. I see some heads nodding back there. Depositions from the witnesses, and then present them to the court to have them accepted for probate. It's just easier to go ahead and get the notary in there too. It takes 3 people to do the will other than you. Administer a will of any type, any of these types of wills is going to require that probate process. You put the will on record, you file the inventory, you file the accountings, and you satisfy the Commissioner of Accounts. All of that costs time and money, and here is how you avoid that. Most of the planning we do is with a revocable trust. So a revocable trust, don't let the word trust scare you, because trust can mean 100 million things, but this type of trust is a bucket that you put your stuff in. Okay, so you're retitling assets to your trust. You've got to handle, you're the trustee while you're alive. Maybe your spouse is also, or maybe she is after you. But you've got 100% control. You're not giving up control of anything by creating a trust. And when you die, anything that's titled to or payable, like PODs and TODs and beneficiary designations, titled to or payable to the trust avoids that probate process. So it's not about taxes. It's not about losing control. It is about making it easier for those to come behind you and have to do the distributions and so forth. So I will tell people all the time, and I've only had one decide to change their plan when I said it, this does you no good. It's going to benefit your trustee and your beneficiaries greatly. I mean, hundreds of hours and probably 18 to 24 months of probate on an easy one. So you've got an agreement with yourself as trustee, so you're wearing 2 hats. I created it and I'm in charge of it. And you can change it. So you put the kids in equally and somebody doesn't show up for Thanksgiving dinner, now it's 60-40. They don't come to Christmas, it's 70-30. You can put provisions in there with specific distributions. There's a statute in Virginia that allows you to make a memo on tangible property about who gets what specific items, separate and apart from your trust and your will. And that's really neat, because then you can give one niece the diamond ring and the other niece the, I don't know, something else. I had one client that had 2 diamond rings. One was substantially bigger than the other. And she would change her memo. Every time somebody came to see her, she'd switch the memo. So if you were the last niece to come visit her while she still was clear, you were getting the bigger diamond ring. So you can revoke and amend it. If you're incapacitated, your authority to revoke and amend is over. The trust is locked in place. At your death, all the terms of the trust get administered by the trustee. So anything that's in there is going to avoid probate, which is the big deal. Here's what you've got to do to make that work. So having that perfectly drafted document from your local lawyer is half of it. You got to put the stuff in it. Remember the bucket? So title changes on real estate, title changes on accounts. It goes from Alfie Butts to Alfie Butts trustee of Alfie Butts' trust. PODs and TODs, take my little securities account, I make a transfer on my death to my trust. It's in my name during my lifetime, nobody sees the word trust. At my death, it automatically flows, the trustee shows up with my death certificate, the trust agreement, and grabs it. Makes the distributions to the beneficiaries. TODs for closely held businesses, so a lot of people have rentals. They've got their rental property in LLCs, they've got consulting businesses left over from when they were working in LLCs. And we, instead of grabbing that corporate book off the shelf and fiddling with those certificates, we do a transfer on death document that says my interest in this entity or these entities goes to my trust at my death. So it avoids probate. Really easy, it's short. If you've got money, people that owe you money, if you've got accounts receivable, we can do assignments for those. So you assign those accounts receivable to the trust. Deeds of gifts for real estate, you're not transferring it. There's no transfer tax on these deeds, on these transfers. So you're giving it $27 it costs to record these deeds. Putting the real estate into the name of the trust so that it avoids probate. That is generally the big asset, and that's generally the biggest savings as far as probate tax. So if you got $1 million house, you can save a couple of $1,000 of probate tax just by doing a $27 deed of gift. That's what it costs to record it. That's not what the attorney can charge you for. Out-of-state assets. If you own anything out of state, you need to do this work. Out-of-state probate is what we call ancillary probate. You don't get to do out-of-state probate for your beach house until you do the probate here. So you don't have to do one, you actually have to do two. And your lawyer here generally does not want to do the probate in North Carolina or Florida, and especially California. So you're going to end up paying somebody out there to do it. And let me tell you how bad it is. We had a probate of a $500,000 house in California, which was not, it was this big. It cost $15,000 to get that through probate. That house here might have been $1,500 to get it through probate. And I'm not talking about the court, I'm talking about the lawyer's fee. So it is, they take full advantage of the out-of-state folks when it's time to do the ancillary probate. You can avoid it by transferring those out-of-state properties into your living trust.
Are you only talking about properties? You're not talking about like a bonds or a bank account that
your
you have
bonds
in
aren't-
another state?
Well,
If it,
but,
you know,
okay.
if you have some assets in Connecticut or, you know, or,
yes, if
That
you got a bank in Connecticut that doesn't have a Virginia branch, then you need to make sure that those accounts are POD to your trust, because you're not gonna be able to get to them without going up there. And if they've got a Virginia branch, then you can get to them with a Virginia probate. But most of what we're talking about is real estate. Yes, sir.
If they're out of country, what complication does that
A lot. All right, depends on what country. So, I had a client who would go back and forth between 4 countries. So I did a plan here for her. She did a plan in Uruguay. She did, I don't even remember where the other 2 were. There's one in Europe, 2 in Europe, and one in South America, and one up here. So she had a separate plan in each one of her plans just to control the assets in that country. And that's the easiest way to do it, but you gotta get around and get it done. You can, in some countries, title things to your trust, but with the documents and the Hague Apostles that they require and the things that you have to do to get it, it's not the way to do it. The way to do it is have a separate plan for each country, so that it controls that. And I tell you what, Canadians hate trusts. I can't get anybody with Canadian property put it in the trust. They end up going up and seeing an attorney up there and doing a will, because the attorneys tell them, don't do it. It's insanely difficult to get anything administered that's titled to a trust, U.S. trust. So, sorry. It'll double and triple the work for you, but that's the way to do it. Let's see, where were we? Beneficiary designations, you gotta think about all those life insurance policies, IRAs, how they're gonna go, contingencies. If they're gonna go to descendants, you need to put descendants for stirpies in there. You really gotta pay attention to the details on those things. Generally, my advice is to take tax-deferred assets like IRAs and annuities, if they've got a lot of appreciation in them, and pay them directly to people. don't run them through the trust, because the people will get to defer the tax for either the contract term or for a 10-year period with an IRA. The trust isn't gonna get that advantage. If your beneficiaries are minors, maybe you pay to the trust. Then there's some other situations where it makes sense, but generally IRAs are gonna have people and people and people. Your cash accounts, your non-deferred accounts are gonna have trust as a beneficiary to keep it out of probate. And again, if you pay those IRAs to people, it's not probate, it's got a designated beneficiary. Unique assets, royalties, copyright, contracts, timeshares that are not exactly real estate, they're point systems, you gotta deal with that, you need to do an assignment or something. Crypto, I bet nobody in here's got crypto, anybody got crypto? I don't know. Okay, so that's unique in and of itself, and you can just make sure somebody can get to it, because if they can't, it's gone. Safe deposit boxes. Let me give you a little warning about your safe deposit box. Fantastic thing to have. Make sure somebody else is on it. If it's a couple that own the box, make sure one of the kids is on it. You don't have to give them the key, but they need to be on the card, or when you die, if you got everything in your trust, they still need to go qualify as executor to get the box. I had to do that the other day and drill one. I've drilled 3 in the last 2 years. The first 2 were completely empty. I think one had a paper clip in it. The last one had some gold coins in it, which was fun to see. So I always videotape that stuff when I go in. But safe deposit boxes cannot be assigned or titled to your trust. So you need to make sure that either your executor that you've got named is on there or somebody that you trust. That's the end of it. How'd I do on time?
Perfect.
Okay, I will take other questions if you've got some. Yes, ma'am?
Silly, but it takes weeks for you to die, and they take your organs, who's paying your medical expenses?
Okay, so once they
The state?
decide that they're gonna do that, you're not paying any bills.
Okay,
The organ procurement group takes care of that.
okay.
Yeah, that would be tragic if they handed your family a 2-week life support bill.
Yeah, that's what I was wondering.
Yeah, I didn't talk about tax avoidance. I didn't get into the details of that. There's a lot we can do to avoid estate taxes, and they're supposed to come down. You got a $12.9 million credit, but in 2026, it's gonna roll back, and it's probably gonna be half of that. So if you find yourself with $10 or $12 million, please make sure you get some planning done. If you don't have $10 or $12 million, the lottery is like 500 million tonight, so. Sign the ticket, run to Richmond. Yes, ma'am?
I loved your comment about UTIs. I went through it with my mother, it is so true. Absolutely.
I had a client.
For anyone who doesn't know it.
Okay, I had a client that would get one every 6 to 8 weeks. As soon as she was clear, I was the best lawyer on the planet. When it started, I was, words I really don't want to say on Facebook Live.
We looked at you like you had 3 heads. That's
Well, it
what
was
I
worse
was
than
saying.
that. So,
Why
yeah,
is she looking at me that way? And that's, the nurse would say, probably because.
check it out. Get her some antibiotics. Yes, ma'am.
UTI, what is a UTI?
Urinary tract infection.
Oh, okay.
Actually, the change in your blood chemistry, the older you are, the more effect it has on your mental capacity.
Oh, really?
Yeah.
Oh.
It's temporary. It's wicked.
I didn't know that.
Okay. Thank you. If you got other questions you don't want to ask on camera, I will stick around for a minute.